So Hensler declares that the marriage has become very unsupportable unless she consents to having her mouth surgically closed. My God, man. Holy cow, you put this in front of the court. A pleading is a document that you file with the court, and whenever I file a pleading, it is well-researched, it makes good faith, well-reasoned arguments, and it is spell-checked within an inch of its life. But the pleadings we're talking about today have none of those things. These are the most bizarre and ridiculous pleadings that have ever been filed in an American court. We start with the Iowa man who requested trial by combat. So in America, we take pride in a judicial system that allows anyone to have their grievances heard before a neutral judge or a jury of their peers. And instead of resolving disagreements through duels like the days of yore, legal disputes can be addressed in a calm and civil manner. Well, that is the ideal, at least, because reality is often much, much different. Enter David Ostrom of Paola, Kansas, who during a heated custody battle against his ex-wife requested an Iowa court turn their legal battle into a literal battle, complete with samurai swords. In an effort to resolve a dispute over his ability to communicate with his two children and get his ex-wife to pay property taxes on their former home, Mr. Ostrom filed a motion challenging his former spouse and her attorney to, quote, trial by combat. Mr. Ostrom was purportedly inspired by Richard Luthman, a Staten Island attorney and Game of Thrones aficionado, who requested a trial by combat to settle a dispute with another lawyer and his clients. In Mr. Ostrom's motion, he wrote, "My ex-wife and her attorney indicated they have destroyed me legally. Now I wish to give them the chance to meet me on the field of battle, where I will rend their souls from their bodies." Mr. Ostrom, ever the chivalrous type, said his ex-wife's attorney would be allowed to fight in her place as her, quote, champion. Mr. Ostrom defended the legality of this request before the court by writing, quote, "Trial by combat was still regarded as a legitimate method for dispute resolution when the Constitution was ratified in the United States by the original 13 colonies. To this day, trial by combat has never explicitly been banned or restricted as a right in these United States. Checkmate, never rescinded, still okay. That's how the law works, right?" So Mr. Ostrom also requested a 3-month delay so he could obtain 2 samurai swords for the fight. In opposition to Mr. Ostrom's medieval motion, the counsel for Ostrom's ex-wife, who refers to himself in the response as, quote, potential combatant, very cheeky, that is an excellent defined term, argued, quote, although the respondent and potential combatant do have souls to be rended, they respectfully request that the court not order this done. We humbly request that the court deny this motion, as the potentially life-ending ramifications surely outweigh the severity of the petitioner's proposed legal remedy of trying to avoid responsibility for property taxes and to acquire additional telephonic communication. What a buzzkill. Seriously. Now, I regret to inform you that the judge denied Mr. Ostrom's motion while granting opposing counsel's request to temporarily suspend Mr. Ostrom's child visitation rights and order a psychological evaluation. Like, a guy can't just request trial by combat to the death? I mean, judges. Mr. Ostrom was declared sane and then demanded his ex-wife and her attorney also get sanity tests. Mr. Ostrom insisted he was neither violent nor crazy and had no intention of hurting anyone. Rather, he was simply frustrated with what he believed was a system stacked against men in custody disputes with financial support and wanted to draw attention to the issue. Now, trial by combat is technically illegal in almost every state. And in fact, in Kentucky of all places, there is an anti-trial by combat law that says every elected official who takes the oath of office must actually swear before God that they never fought in a duel with deadly weapons nor challenged or aided any in such fight. Now, hashtag not legal advice. Regardless of the legality of trial by combat, it's probably a bad idea to settle disputes with deadly weapons, especially if you want to get elected in Kentucky.
Nor have I sent nor accepted a challenge to fight a duel with deadly weapons.
But that takes us to perhaps the most bitter divorce filing of all time. And as you just saw, emotions can run high in matters of the heart. That's why for divorces, it's often a good idea to hire an attorney to proceed with an air of professionalism. Or you could just choose the path of Texas attorney Paul Frank Hensler, who handled his own divorce with a handwritten petition that was Well, it was interesting. Let's just take a look at this. Now, fair warning, this is a 1985 divorce petition from Texas, so don't be surprised from what follows, where it's not exactly the most evolved of pleadings. And in what reads like a badly written country song, or honestly an awesome country song, Hensler states his wife moved out of the house after only 10 months of holy matrimony, after she got pissed off and hauled ass with their car, the MasterCard, her $365 in cash, her federal civil rights 9-year-old employment discrimination case against the Texas Department of Human Resources, to which she is welcome, having bored me stiff for 2 years about just how everybody picks on her. So Hensler declares that the marriage has become very unsupportable due to a conflict of personalities between he and his wife, but says the real blame lies with his ex-wife's failure to provide the, quote, legitimate ends of the marriage that prevents any reasonable expectation of reconciliation, unless she consents to having her mouth surgically closed. My God, man. Holy cow, you put this in front of the court. Now, Hensler attests that he and his wife had no children together, although, quote, petitioner swears on oath he did everything he could to knock her up. That's not even germane to the pleading here. But Hensler sarcastically says his wife is, quote, liberated now and feminists don't have children by male chauvinist pig lawyers. So she swears. Gosh, I can't believe this marriage only lasted 10 months. Now, Hensler requests the court divide their estate among parties based on possession, clarifying he means the legal sense of possession, not possession like in horror movies. But Hensler does assert his wife could easily stand in for, quote, the girl from The Exorcist.
And the Holy Spirit.
Hensler requests the court grant his divorce and have his wife's name legally changed to the demonic Bella Abzug Jr., a play on the name Beelzebub. Hensler then closes the petition with, quote, screw you, bitch, while signing the pleading with respectfully submitted Paul F. Hensler. Fun fact, lawyers who sign things respectfully, 9 times out of 10 were secretly meaning no respect intended, except me, of course, always with due respect. Hashtag not all lawyers. But that brings us to the defense attorney who demanded that everyone call him Captain Justice. Now, to promote the fair administration of justice, courts serve as evidentiary gatekeepers to ensure only reliable and authenticated evidence is admitted at trial, while excluding any evidence that needlessly inflames, confuses, or prejudices the trier of fact. But in one Tennessee burglary case, the dueling efforts of prosecutors and defense counsel to obtain a fair trial took a very bizarre, and let's call it a humorous turn. Now, back in 2013, the state of Tennessee was scheduled to prosecute Donald Powell for aggravated burglary. Assistant District Attorney General Tammy Rettig was the local prosecutor who represented the state, while Powell was represented by an appropriately named Drew Justice. Before trial, ADA Rettig filed a motion in limine to get the court to exclude evidence she believed would unfairly prejudice the state's case. Her request: stop defense counsel from referring to the state's legal representative as the government, because that's not very nice. Yes, that's right. The prosecutor who represented the government of Tennessee demanded that the defense counsel be prohibited from calling her the government because it might bias the jury against, let me see here. The government. Now, in ADA Rettig's one-page motion, she suggested Mr. Justice's repeated references to the state's attorney as the government was derogatory and prejudicial to the state's case, and Mr. Justice should instead refer to the state's attorneys by their names or titles. Mr. Justice responded to this baffling motion with his own appropriately cheeky response. The government has moved to ban the word government, Mr. Justice begins, noting that the state of Tennessee, quote, offers precisely zero legal authority for this rather nitpicky position. Mr. Justice argues granting such a motion would violate his First Amendment rights. Mr. Justice asserts that the term the government is not inherently derogatory, particularly since courts frequently refer to the prosecutor's office as the government. In the alternative, Mr. Justice argues that if the ADA gets to choose her own name, then we, the defense, should get to choose our own names as well. Mr. Justice first requested the court stop referring to the defendant as defendant, stating that the word has a negative connotation that, quote, dehumanizes Mr. Donald Powell. Mr. Justice instead proposed calling his defendant by his full name, Mr. Donald Powell, quote, the citizen accused, or that innocent man. But Mr. Justice was not yet finished. He asked the court that he no longer be referred to by the meager name of lawyer or attorney, That's when Drew Justice went full Ted Mosby.
Pleased to meet you, Captain. I'm Galactic President Superstar McAwesomeville.
First, Mr. Justice suggested that the court call him Defender of the Innocent. As all defendants are presumed innocent until proven guilty, he then proposed the title of Guardian of the Realm. Mr. Justice also suggested that if ADA Rettig gets to be, quote, Assistant District Attorney General, then defense counsel deserves an appropriate military title to match, Captain Justice. Captain Justice argued that the court shouldn't even be calling him the defense, writing the, quote, whole idea of being defensive comes across to most people as suspicious. The captain then proposed that his side instead be dubbed the Resistance. And as a Star Wars fan, I can certainly see the appeal of that last one. But the cheeky defense counsel closed his motion with a similarly wry fashion, quote, wherefore Captain Justice, Guardian of the Realm, and Leader of the Resistance, primarily asked that the court deny the state's motion as lacking legal basis. Alternatively, the citizen accused moves for an order in limine modifying the speech code as aforementioned, and requiring all other euphemisms and feel-good terms as the court finds appropriate. Now, you might have thought that lawyers are incapable of committing extensive trolling in court, but this motion shows just how wrong you are. Sometimes if the prosecution does ridiculous things, you gotta just troll the crap out of them. Now, sadly, the court denied the Assistant District Attorney General's motion, while also denying defense counsel's request to be called Captain Justice. Tennessee's fears that being called the government would prejudice their case turned out to be unfounded. After waiving his right to a jury trial, Mr. Powell was, in fact, convicted of attempted aggravated burglary, and his conviction was upheld on appeal. But it seems like Mr. Justice's suggestion that his client be called, quote, that innocent man, was just a little bit premature, if not incredibly petty trolling. So, A+ on that. But that takes us to an actual meritorious motion, because one of the best reasons, if not the best reason to ask for a continuance, is that the Chiefs made it to the Super Bowl, man! Now, of the many skills that lawyers possess, one we certainly lack is the ability to see the future. But one possible exception is DUI attorney and Kansas City Chiefs superfan Denise Kirby, who successfully predicted in a legal filing that the Chiefs would break a 50-year championship drought that would render her too busy cheering on her team at Super Bowl 54 to attend trial. Here's how it went down. Now, in October 2019, Ms. Kirby filed a motion to continue her February 3rd, 2020 DUI trial on the grounds that she'd personally be in Miami watching her team play in Super Bowl 54. At the time of the motion, the concept was laughable, so much so that apparently everyone in the courtroom laughed at her request. But then the Chiefs made it to the Super Bowl, so Ms. Kirby filed a new motion to continue trial. According to Ms. Kirby's motion, quote, the courtroom erupted in laughter when she confidently asserted in October that she would be in Miami to watch the Chiefs in the Super Bowl. She further noted that the court had advised that, should that happen, it would grant the continuance. Quote, it happened, wrote Ms. Kirby. As a result, Ms. Kirby would not be back in time for trial and thus needed a continuance. The motion ends with, quote, go Chiefs, because of course it does. Now, ultimately, the Chiefs and Ms. Kirby would have the last laugh. In a historic fourth quarter comeback, the Chiefs overcame a 10-point deficit with 21 unanswered points to beat the San Francisco 49ers 31-20. It was heartbreaking. I was born in San Francisco. I'm a big 49ers fan. Sorry. The court, having granted Ms. Kirby's continuance, helped fulfill the prophecy that allowed her to see that historic victory. And that takes us to the importance of being earnest. Hemingway. Now, lawyers have a reputation for being humorless buttoned-up suits.
Well, I'm a professional. I'm serious and I'm a professional.
Can't imagine why. But we lawyer types love to cut loose and have some fun. So what is an attorney to do when our extracurricular activities clash with trial dates? Well, if you're Florida lawyer Frank Lauterbach, getting ready to attend an Ernest Hemingway lookalike contest, you hope that your court is understanding of your scheduling conflict and non-refundable deposits as well. The court was not. Here's what happened. In 2012, Florida man Jerry Allen Batorf was facing federal charges in connection with a murder-for-hire plot involving the murder victim's wife, Christy Seahorn Batorf, whom Jerry had met at a swingers club and who later became Jerry's wife. Just your typical Florida love story. Now, Frank Lauterbach was scheduled to go to trial in July of 2012, but everything changed for the St. Petersburg lawyer when he became a semi-finalist in the annual Ernest Hemingway lookalike competition at Sloppy Joe's Bar in Key West. Now, Lauterbach understandably felt that this fortuitous change in circumstances merited a brief suspension of trial, informing the court, quote, "Undersigned counsel has secured a block of 6 rooms to accommodate family, friends, and fans, and has had to pay non-refundable deposits." Now, non-refundable deposits notwithstanding, U.S. District Court Judge Stephen D. Meriday denied the request, writing, quote, "Between a murder-for-hire trial and an annual lookalike contest, surely Hemingway, a preferred admirer of, quote, grace under pressure, would choose the trial." And in his denial, Judge Meriday showcased his own sense of humor and admiration for Hemingway, citing Dorothy Parker's 1929 New Yorker profile of the author, quote, "At his most robust, Hemingway exemplified the intrepid defense lawyer. He works like hell, and through it, he has the most profound bravery. He has had pain and the kind of poverty that you don't believe. He has had about 8 times the normal allotment of responsibilities. And he has never once compromised. He has never turned off on an easier path than the one he staked himself. It takes courage." Judge Meriday closes the motion by citing the iconic final line of Hemingway's "The Sun Also Rises." And you've got to love the way that the judge ends this order. Best of luck to counsel in next year's contest. The motion, docket 127, is denied. And while Louderback would live to compete another day, sadly, Betorf and his wife pleaded guilty to the charges and were sentenced to life in prison, and in perhaps the greatest miscarriage of justice, would never live to see a Hemingway lookalike contest. Of course, none of these lawyers' pleadings make any sense. They are completely illogical. They could really use a logic or math course from Brilliant. Today's sponsor, Brilliant, is an online learning platform for STEM that replaces lecture videos with hands-on interactive lessons. Brilliant is for curious learners, both young and old, professional and inexperienced. One of my favorite courses is all about logic. Brilliant's logic courses covers liar and truth teller riddles, logical fallacies, machine logic, and even some strategic game theory. Logic is, of course, a crucial skill that lawyers need every day. Not the ones that we covered in this video, but at least lawyers, generally speaking, nonetheless. And Brilliant lets you learn by doing rather than listening to hours of boring lectures. Learning through doing is scientifically proven to be the most effective way to master any skill. The courses have storytelling, interactive challenges, and problems to solve. Within Brilliant's library, you'll find courses and topics like calculus, linear algebra, and math. That applies to trading and finance. You'll also find courses on gravitational physics, astronomy, and machine learning. And you can level up in just 5 minutes a day by working on the daily challenge. Each daily challenge provides you with the context and framework that you need, so you don't have to take a deep dive if you don't want to. You can sign up and start learning for free today at brilliant.org/LegalEagle, or you can click on the link that's on screen right now or in the description. The first 200 people to sign up will also get 20% off their annual subscription. Plus, clicking on that link really helps out this channel. Or click on this link over here with all of my other legal videos, so click on screen, or I'll see you in court.